have children and you want a divorce in Cook County, you have to submit a form of personal information to the court before that divorce will be granted. That's been the rule in divorce court for more than a year. And as Deborah Norville reports on today's Monitor 5, it's beginning to cause some would-be divorced couples some problems. Deborah?
Linda, the form asks such personal information as Social Security and bank account numbers, things that some people would rather keep to themselves. The idea is by having that information on file, a parent who is entitled to child support payments is more likely to get them. But as at least 2 Chicago couples have found out, the rule can also prevent people who want a divorce from getting one. Abel Montenegro is deeply attached to his 2-year-old son, but he says his marriage of 5 years is no longer working. He wants a divorce, but his attorney said even though he was married in Chicago, since Montenegro's wife is an illegal alien and has no Social Security card, he can't get divorced here.
I couldn't get divorced until she has her Social Security. And for her to get Social Security, well, it's a lot more red tape you got to go through now. But it's like I said, I still can understand it. I still don't understand it.
Neither do Ophelia and Ramon Ramirez. Married 7 years, they decided 1 year ago to get divorced, agreeing in advance on child support and custody of their daughter Jessica. Everything went smoothly until it was time to file their divorce decree.
He says he came to my office, he filed the papers, and much to his surprise at the end, after signing, he never got his divorce.
The Ramirez divorce did not go through because they had not completed this form, required in all Cook County divorces involving children granted since January of 1982. So the Ramirez attorney filled out the form.
I went back a second time, and I took the form, and when it came to her Social Security number, we actually left it unknown. Not even blank, just unknown. And they bounced it back. So in a sense, no Social Security, no divorce.
Ophelia Ramirez's Social Security number was not listed because she does not have one. She is an illegal resident of the United States. And even though she no longer lives with her husband and has every intention of getting a divorce, in Cook County at least, she can't. The Ramirez and Abel Montenegro have been caught in a bureaucracy that was set up 1 year ago to help stop an increasing number of men who were reneging on their child support obligations. Under the program, unless the couple agrees otherwise, child support payments are made to the clerk of the court, who forwards them to the child's other parent. If the payer defaults, the clerk notifies him and then begins disciplinary action if payments are not made within 60 days. Information contained on this form to be filed along with the divorce decree is supposed to make collecting those payments easier. But attorney Michael Ramon says to him, it smells like police work.
They want to know whether or not he's got any scars or tattoos, and if so, where. How much does he weigh, if he wears glasses. Very personal and private information, which sounds like they're preparing a warrant for his arrest before he actually falls behind in any payments.
According to county officials, 82% of the divorces involving child support do fall behind in payments. Attorneys for the Ramirezes, though, contend that's not enough reason to ask for the information, and filed suit in the state Supreme Court asking that the case be reviewed. The court denied that petition, saying the case should be heard in circuit court instead. We tried to get officials from the state's attorney's office, the clerk of court, and the domestic division of the court to talk with us about this, but all declined because the case will probably go back to court. However, one official with the clerk's office involved in the child support enforcement program told me that denying the Ramirez divorce goes beyond what was originally intended by the rules. He said by having the information on file, they all thought it would be easier to collect payments if a parent should default, but he thought that it was a good system that would help the public. However, Burton Grant, a family law professor at DePaul who is handling the appeal on the case, says there are other ways to get the same information, like going to the state driver's license division. He plans to file an appeal of the Ramirez divorce within 10 days.
Take committee chairmanships.
Of the relationship between divorce and your Social Security number. And Ain't Nobody Better Than You is the title of a new autobiography by Greyhound Corporation Vice President Joe Black. Joe will join me shortly to talk about his book, but before any of this happens, let's take this time out for messages. Failure to disclose one's Social Security number or the failure to have one at the conclusion of a divorce case can prevent the Court of Cook County, as well as courts in other Illinois counties, from granting a divorce in cases where the parties have minor children. I know that's all a mouthful, and we've said quite a bit in just a short period of time. But here to explain more in detail the meaning of all this, I'd like for you to meet my guests. First, attorney Michael A. Roman and attorney Burton F. Grant. Both gentlemen are involved in defending couples with this type of problem. Gentlemen, good morning. How are you? Nice to have you here. What's the big deal about having the Social Security number? I know a lot of people haven't really thought about this.
Well, I think it's best explained if we can go into the history of what's happened in Illinois in the past year and a half or so. Last January of 1982, the state of Illinois enacted some new law which now allows for the payment of child support through the clerk's office of the various county clerks. And this was done and done with a proper motive to enable collections of child support to be made more effectively. And the problem now, though, is in doing this, in enabling the system to work through computers in most counties, they are requesting couples to give certain personal information. It's been my experience in my practice handling mostly divorce law and representing couples in custody cases and divorce cases that most of them elect not to use the system. They still prefer to have child support paid directly from one to the other. It's a little faster, and in many cases, a husband or wife, as the case may be, whoever is to receive child support, really doesn't want to go through the red tape. But the Cook County system requires these people, even those that don't want to use the system, to still fill out personal information, which, if it's not completed at the end of the divorce case, their divorce will not be granted, even though they've complied with other state laws which are relative to proving jurisdiction, proving grounds exist, proving all the other things that the statute requires. The judge will not grant the judgment for dissolution of marriage because they refuse to give out information. Now, some couples don't give it out because they don't have the information. Some don't give it out because they want to stand on their constitutional rights, one of which is the right of privacy. In 1974, we found that our country enacted legislation federally which now allows people to protect certain privileged information from having to be divulged, such as Social Security numbers. And that information, now being privileged, should not be required to be divulged by county clerks. I believe it would be fair to ask someone to divulge certain information to help to make the program effective, make it work. But for those who aren't going to use the system, they should be not compelled to have to give that information.
And this basically is what the petition that you have filed basically states, I mean, in layman's terms. Am I correct?
Right. Specifically, we are attacking the validity of this document, which I have before me. It's called a Family Support Memorandum of Judgment form. It calls for very specific private and personal information. It calls for both spouses' Social Security numbers. It calls for the complexion of the male, his weight, his height, whether or not he's got his car, a tattoo.
What does that got to do with getting a divorce, which is...
Exactly, that's our objection. This sounds like a prepared arrest warrant and the presumption that every father is going to go delinquent. And I believe this runs contrary to our system, which is a presumption of innocence until proven guilty. Several fathers, and specifically a certain couple that came to me, they had one child. It was not contested. They wanted to get divorced, so we went through the trial court. The court found jurisdiction. They found grounds. And the judge also found that the marital agreement, which they had entered into between themselves, was equitable, fair. So at that time, the judge asked me to come back to the court and prepare the documents, which is the decree, the divorce decree, and he would enter it on the books. To my surprise and my dismay, that of my clients, after have paying me the fees and the cost, I went back and the clerk refused to enter the decree on the appropriate books on the sole basis that my clients refused to submit this document. Now, I explained to him, I said, it sounds to me that this is unfair and is contrary to the 1974 Privacy Act that Professor Burton Grant was referring to. You see, the 1974 Privacy Act it specifically states that when any governmental or state agency asks for anyone, you or I or any person, to disclose his or her social security numbers, they must cite on that document, that agency must cite on that document where they are getting the authority to do so. And on this document, nowhere on the face of this document does it appear the site or the citation, the authority by which they are proceeding under. This is another one of our basic contentions and disagreements that we have with this type of a system. We are not attacking the program per se, which has, as you know, has been in force since January 1st of 1982.
Sure.
We are saying that the program should be voluntary and not mandatory for people, as Professor Burton has stated, for people that want to participate in the program. They, of course, the social security numbers are crucial because that's how the computers work.
All right, when we, in setting up this program, when we talked to representatives of the city clerk, they mentioned the fact that the Social Security number is important in trying to trace down fathers who have refused to pay child support.
Well, I disagree with that, Wanda. Anybody can change a Social Security number at will. There's a parallel to this, too. The Secretary of State's office, prior to 1975, also required Social Security numbers to be affixed to your driver's license.
Mm-hmm.
In 1975, shortly after the Privacy Act was passed, they now do not require it mandatorily to be given, but it's discretionary. You may give it if you want. You don't have to give it if you don't want. The Secretary of State's office, by statute now, can assign you your own number, a different number, separate from a Social Security number. And we believe that Cook County can do the same thing. They can use the case number itself. They can give you a different number. They can use a federal employer's number, but not a Social Security number. Social Security numbers, by the way, most people don't understand how much information can be gained from a Social Security number. If you know someone's number and you wrote to the Department of Health, Education, and Welfare and asked for all employment information on an individual, you would get a computer printout of that individual's total employment background. All the money they